Okay, so now we go to the National Advertising Division, NAD. And that, who's familiar with that organization? Does anybody know about that? Okay, this is a voluntary organization. It's really an alternative dispute resolution forum. That's primarily what its purpose is, and it's for national advertising. And if an advertiser puts out a national ad and a competitor views that ad as being untrue, unsubstantiated, and so forth, it can file a claim with the NAD, and the National Advertising Division will then challenge. If it believes that the challenge is worthwhile, it will then ask for substantiation from the advertiser, from the challenged ad. And it's a great alternative to federal litigation because it's a 60-day process. The NAD it's a very inexpensive, well, relatively inexpensive compared to federal litigation. And then the decisions are rendered in 60 days. It's voluntary. That's one of the important things about the NAD, is that it's a voluntary compliance. No one who receives a demand from NAD is required to comply, but there's a 96% compliance rate with respect to the decisions that the NAD makes. And the reason why is because if you don't comply, the NAD will then refer the case to the FTC or to state attorneys general or others. Their decisions are published. Yeah?
Is this only for consumer? Do they only get involved in consumer advertising, or business advertising as well?
Business, it's any advertising.
Okay.
And the only criteria is it has to be national advertising. They don't get involved in local advertising. You can see going back to this page, the Mead-Johnson case here. Mead-Johnson makes the Infamil product, which is a baby product. Jimmy knows all about Infamil, I know. But the claim was there that the Infamil product was the only formula of its kind, and it was not replicated in store brands. And some of the store brands brought an action they first went to NAD and said, this is not true. By the way, we are getting our products from the exact same supplier, and the products are identical, so it's literally a false claim. And so the NAD rendered a decision, and Mead-Johnson did not follow the decision, and so then the competitor sued, and so now that case is going forward. So that's the kind of type of a situation that happens. These last two I'll just spend a minute on. There are each state, I think there are 38 states now, or 39 states, that have things called the Little FTC Act, and they're replicas of Section 5 of the Federal Trade Commission Act, and they allow private citizens and the AGs, the Attorney Generals, to take action against false advertising in their state. So you see, these are big-time cases. If you get one of these, it's a terrible publicity situation. If the state attorney general is coming after you for false advertising, one of the things that's different about the state attorney general cases and the consumer class actions is that in both cases, those parties have the obligation to prove the falsity, as opposed to up here with the NAD. If you get a NAD challenge, you have to prove that your ad is true. With these two, they have to prove that the ad is false. But the problem is, a state attorney general has wide investigative powers and can make life a living hell for whoever gets challenged. So it's a real, and of course the fallout from bad publicity is just terrible. Consumer class actions, these are on the rise. And it's a funny thing for lawyers because logically you would think this is not the type of case that would be certified for a class action, because typically like tobacco you think that's harm caused by a single product. But false advertising cases hinge on reliance on the ad that is misleading that then harms the consumer. And so you would think that the reliance issue is not something that a group of consumers have in common necessarily, but in California they have certified these classes, and so this is a big concern now. It's a much bigger concern than it used to be. And one of these cases, let's see, which one was it? Let's see, there was a case, let me see which one it was. Oh, I know what it was. There was a Subway case. Oh yeah, this was December of last year. There was a case against Subway. It was consumer class action, and Subway's ads had said that they were offering discounted sandwiches. And then when consumers went in, the discounts weren't being honored at the stores. So a consumer class action was brought, and Subway had to pay. This shows the craziness of this. There was no way to pay the consumers, so Subway had to give out $2 coupons, $645,000 worth of $2 coupons to every consumer that walked in the door over a certain period of time, irrespective of whether that consumer had any role in being harmed from the prior action. So you know, yes?
But how does that cause harm to the consumer? If
The discount's not being honored?
yes.
Well, it's false advertising. So the ads stated that discounts would be given, a certain type of discount would be given to a certain sandwich. The consumer sees the ad, goes in, and the discount is not honored. And so it was, that's the harm, you know. It's just false, yeah, bait and switch.
Was this one of those cases where certain co-ops didn't join into the
Nope.
it was a national, they never disclaimed that.
The,
They never put a disclaimer on.
They never said that not all stores are participating. So the stores that that were supposed to be participating were not honoring it. And it didn't appear that there was any intent necessarily. It was just not being followed. And so you can see how, you know, that's the kind of thing where you just think, oh gosh, I mean, it's you have a nightmare on your hands at that point. So
When these agencies go after the companies, so they're required to cease and desist?
yes, that's one of the big orders is cease and desist orders.
Okay.
You're talking about the ad campaign itself? Yeah, that's the primary first thing. In all of these cases, that's changing the ad or stopping the ad are the primary remedies. So, okay, so now...
Jay, can I ask a question?
Yeah, sure, Chris.
How does a client get contacted? I mean, what's the contact situation? You get a letter in the mail? You get a phone call from somebody?
You get a letter.
Does the Attorney General call you and you get a problem? I mean,
If it's the Attorney General calling, you're going to get a letter. Yeah, no, that's exactly...
I mean, you know,
That's exactly.
clients, how would they come?
I would say that by and large, the people that are most concerned about this are your competitors, are an advertiser's competitors. They're the ones that are watching the ads. And so the most likely situation is that a competitor will write a letter saying, this ad is BS, it's not backed by any kind of scientific evidence, or it's just literally false, or if you're making claims about my product that are false. There was a great case, the case of the paper towels. Let's see, Procter & Gamble made the claim that the Bounty towel had 25% thicker quilts, okay? And the Wall Street Journal picked up on that ad campaign and said, now there's a new towel, it's 25% thicker. Well, what they really meant was the quilts, which are the indentations, were 25% thicker, but the towel itself was not thicker, and in some cases it was thinner. So Georgia Pacific brought an action, first sent a letter saying, this claim is crazy, it's not even true, and it's misleading, and there's no performance benefit to having thicker indentations. It's a misleading claim. So they sent a letter to Procter & Gamble, and so you can see the case has now resulted in litigation. Procter & Gamble said, forget, we're not going to pull the ad, we're not going to change it at all, and so now Georgia Pacific has sued him. So that one started out with just a letter writing campaign, and most of them do. Most of them start out with a letter writing campaign.